Good evening and welcome to HCCLA's Reasonable Doubt. My name is Carmen Rowe and I'm the president of HCCLA, the Harris County Criminal Lawyers Association. We're the largest local criminal defense bar in the country. And tonight we're going to take a look back at the life and career of Kent Schaffer, one of the best criminal defense lawyers in Texas and arguably the nation. He's a past president of HCCLA, the Texas and National Criminal Defense Lawyers Association, and he's been practicing criminal law for over 30 years. He's seen the ups, the downs, the fads, and the trends, and he's going to talk about all this and more with our hosts, Jimmy Ardwan and Damon Parrish.
Good evening, everybody. Thank you, Carmen, for the introduction. Appreciate you all joining us for another episode of Reasonable Doubt brought to you by the Harris County Criminal Lawyers Association. As Carmen said, our guest this evening is HCCLA past president Kent Schaffer. My co-host this evening is Damon Parrish, and we'll be taking your calls about the 8:30 hour. We'll also be answering your questions on Twitter. You can tweet us at HCCLA_TV. That's at HCCLA_TV. And we'll take your questions right here on the air. I want to bring in my co-host, Damon Parrish. Damon, how are you this evening?
All right, and yourself, how are you doing?
I'm doing great. I also want to introduce our guest of the evening, Kent Schaffer.
Well, thank you for having me today.
Well, it's a pleasure to have you. We thank you for coming on the show and look forward to talking about a lot of things with you tonight. But first off, I want to get to, we usually do current events on the show, and so I want to start off with the first one of the week, and that's the Supreme Court ruling in Rodriguez versus the United States. And Damon, if you can, give us a little synopsis of what the court ruled this week.
Absolutely. And you know, Jimmy, it's not often that we get a Supreme Court ruling of a criminal nature of this magnitude, so it's pretty good. So Mr. Rodriguez in Nebraska was riding in his vehicle. He was riding on the shoulder of the freeway, or the road. Of course, that's illegal. He was pulled over by the cops. Cop approached him, got his license, ran it, came back clear, gave him a ticket for riding on the side of the road, and then asked him, hey, do you mind if I let my dog in the car search your vehicle, sniff it, open air sniff? And he said, no. Cop said, okay, hold on. Went, got his dog, did the sniff anyways, found drugs, he got arrested, charged, and ultimately he got 5 years in the federal penitentiary. Took the case to the Supreme Court, where the Supreme Court ruled that at that point, when the stop was for a traffic offense and the stop was completed with the ticket, there was no need to hold him there for an open-air drug sniff. It was unreasonable, and so it was vacated. It was reversed. The length of time was only 7 minutes, so that's pretty cool.
Ken, I want to get your opinion on this because you've done a lot of drug cases. In fact, you've represented a lot of cartel members, a lot of heads of the cartel. You're very familiar with Fourth Amendment stops and drug issues. What's your take on this case?
I think it's a great result. You know, that over the years, these dogs have been held to be more reliable than any police officer, police detective. I mean, we take the wag of a tail or a passive or active alert and sort of transmogrify it into being testimony from a dog. And the truth is that often the police will lie, flat out lie, about whether the dog alerted or not. We have case after case, and I know both of you have, where an officer says a dog alerted, and you watch it on videotape and the dog doesn't do anything. They say, well, if the dog sits down, it's an alert. If the dog's tail wags, it's an alert. You know, a dog could walk up to a car and maybe there'd been a female dog in the car, the day before, and he picks up on that. And maybe he's alerting to that. Maybe he's just sitting down because he knows he gets a reward every time he sits down, and they call that a passive alert. So you don't really know what's going through the dog's mind, and we've seen search after search where they don't find anything in the car. Does that mean that the dog's not reliable? Maybe, maybe not. So at least the Supreme Court, by coming out with this decision, has put some limitation on the police. But as we see, every time there's a law that kind of goes our way, every time there's a court decision that goes, toward civil rights and liberties, the police will find some way to destroy that. Now what you're going to see is when a police officer pulls over a black or Hispanic person and they think from the get-go that this person has drugs, what they'll do is they'll call for the dog before they even walk up to the car, so that by the time they get the consent or don't get consent, they'll say, well, the dog was there. The person didn't have to wait 7 minutes. They'll be a little bit quicker in getting the dog to the scene because 7 minutes isn't much. We've seen cases where it's an hour.
45 minutes,
45
an hour,
minutes.
2 hours.
And Texas courts have said, well, that's not that long. I mean, heck, what's an hour? So I think the police will just become more and more efficient in order to try to get around that case.
Well, Kent, we want to thank you for that, because if they weren't efficient, they will be now, since you taught them how to.
Oh,
how to beat
come
the
on!
case.
They're not watching this show. They're eating donuts and you know, trying to figure out a way to beat the new case.
Well, but it's almost like every time a new case comes out, they analyze, the prosecutors sit down with the cops, they analyze the fact scenario, and they're going to teach them how to get around a certain fact scenario the next time, right?
Absolutely. And what they'll do is tell them, if you really have a suspicion that this person has drugs, take a while to write the ticket. You know, I've had police, I get pulled over all the time for traffic violations. And, you know, the police officer walks up to the car, goes back to his car, and within 2, 3, 4 minutes, he's back with the ticket. But I've seen other cases where it could take them 20 or 30 minutes, because what they're doing is they're calling in to see whether the person has a record, they're having to write the ticket. You know, they could drag their feet in order to give the dog time to get to the scene. Because there are roving patrols, the canine patrols, you know, where an officer will have a canine in the back, and they'll have them in every sector. And so, you know, if they have it timed out where the dog can get there within 5, 6, 7 minutes, and the officer hasn't finished writing the ticket, it won't be unreasonable pursuant to this new case.
Especially in high crime areas or times when the feds are already trying to find your guy anyways.
Oh, right.
There's surprise stings where they happen to pull him over.
But, you know, in Houston, I mean, it's pretty much every area can be described as a high crime area if they want it to be.
Exactly.
You know, I mean, it's, so yeah, the case helps, but all it does is it makes the police become a little bit more, you know, creative in the way that they find ways to try to get around it.
Well, as the practitioners, I think we'll have to just see how this all fleshes out in the court system and the testimony and everything.
It's racially motivated, and I hate to say that. I mean, I'm as white as anybody, I guess, so I'm not just doing it because I think it's self-serving. But how many, you know, white guys in suits get pulled over and they bring a dog to the scene?
Right.
Right.
You know, but yet you go out I-10 where they have, you know, what they call the I-10 profiles, blacks, Hispanics, you know, traveling on an interstate highway, and they've got dog units all over I-10, and they pull somebody over, within minutes there's a dog at the scene over a speeding ticket or changing lanes without signaling, and all of a sudden, can we let a dog go through your car? Why? You know, I was going 5 miles over the speed limit.
Yeah.
If a cop asked me, can I put a dog in your car, I'd give them a response that I can't even say on cable television. But they never asked me.
It's okay. We have Twee out there editing. You can say what you want to say, and she'll
But
bleep it
if
out
there's
real
a
fast.
7-second delay, then I'm okay. But no, if they ever ask you,
No. No.
They're not
Never
going
have.
to.
They're not going to. There's no reason for them to. It's solely a predatory nature of going after minorities. I think we're all in agreement on that.
sure.
Yeah.
Well,
Yes,
we'll
we
see.
are.
Well, obviously, we'll see how it all fleshes out in the courts. But the next current event I want to get to directly involves you this week, Kent, and that is the Ken Paxton investigation. Our current Texas Attorney General has been under investigation for some time now. The Travis County District Attorney's Office initially turned down charges, said they didn't have jurisdiction, punted it over to the Collin County or Dallas County to see who had jurisdiction there over whether or not Texas Attorney General Ken Paxton violated state securities laws with regard to his participation in an investment firm that he was part of when he was a state senator. Just a couple days ago, in fact, you were appointed special prosecutor to take over by the Collin County, I think, administrative judge, correct?
That's correct.
And I know I'd love for you to talk about the case and give us your impression of the facts, but A, I bet in 48 hours you haven't had a chance to really glean too much, and B, now as a prosecutor, you can't really say too much, can you?
Well, I can't really comment on the facts of the case. All I can say is that we've already started to meet with Texas Rangers who were assigned to the investigation and have been for the last week or so. And, you know, we're going to have to learn what the case is about, which we've already started, and just start talking to witnesses and examining evidence and see where it goes. And at this point, I have no idea. I mean, this is a case that could just as easily be no billed as indicted, but we don't know enough about the facts, and even if I did, I just don't think it would be proper for me to comment, because as being a defense lawyer for almost my entire career, or really for my entire career, I'm very sensitive to the rights of a defendant. And even if, hypothetically, charges are eventually filed, I would never do anything to prejudice his right to a fair trial. You know, he's just, he happens to be a public official, and he happens to be what they refer to as the most powerful law enforcement officer in the state, but he's entitled to the same rights as anybody else. And at this point, and up until the time that there could be a charge and an eventual conviction, he's presumed innocent. And I have no reason to think going into this that he's anything but innocent. Now, as we see evidence and the investigation goes along, maybe that'll change, and maybe not. But he's going to be, his rights will be protected by his lawyer as well as by us, unless and until the time comes where he's indicted and convicted.
Now, this isn't your first time to be a special prosecutor. In fact, you were a special prosecutor not too long ago here in Harris County, weren't you?
Right. I was appointed on the 339th District Court to prosecute a lawyer who, actually a lawyer and his wife, who were indicted for, or charged with embezzling $9 million from an employer. The man was in-house counsel to a local company, and he ran off with about $9 million, and the court asked me if I would prosecute. And I never prosecuted anybody before. This was the first time. And it's something I never really thought about doing, never cared to do, never had to do. And I was not geared toward trying to take away somebody's liberty. On the other hand, though, in that case, I'm offended at lawyers who break the law. I think we have a responsibility as lawyers to help people. I mean, we study for it, we take an oath, we should be ethical, we should be moral, we should use our knowledge, our expertise, and the privilege that we have in becoming a lawyer to help people. And when you use your position as a lawyer to steal from your clients, from people who've trusted you to help them with their problem, and you rip off millions of dollars from them, I don't really have any sympathy for them. And we ended up taking the case, and the wife was no-billed and upon our recommendation, and he was sentenced to 40 years in prison.
Wow. I want to ask you about that case, because that case, if I remember correctly, predated the new Michael Morton Act in terms of your inception on the case. And so have you had to go, in taking over this case, have they told you that you're going to have to undergo any kind of special training on the new discovery rules? I guess that's a sensitive issue for all of us as defense attorneys, right? Because we're always wondering what training prosecutors are going through. So have they told you if you are going to have to undergo any training?
Interestingly, the Texas District Attorneys Association contacted us yesterday and said, now that you're prosecuting this case, you're going to have to take this course on turning over Brady or exculpatory materials, which is a great idea. I didn't know prosecutors were actually taking that course. I think some pay more attention than others, but just, for your viewers that aren't lawyers, there's a concept in criminal law that the prosecutor is supposed to turn over any exculpatory evidence. Oftentimes during the course of an investigation, the investigators will find evidence that's incriminating. Right. And if they didn't, there wouldn't be a case to begin with.
Right.
But sometimes they will also find evidence that's consistent with the defendant's innocence. And, a lot of times in the past, there are some prosecutors, not all, who would say, well, this certainly doesn't help our case, so let's bury it. For instance, in the Michael Morton case. Mm-hmm. So you see a guy there that did 20-something years in prison because there was a prosecutor who had a bad motivation. All he wanted to do was win, and so he buried the evidence that would have cleared Michael Morton, simply for the sake of getting a conviction. And so you have an innocent man who is sitting in prison for over 2 decades because an ambitious prosecutor hid evidence. As a result of that, we now have the Michael Morton Act, which requires prosecutors to turn over any information that is exculpatory. So even though the Michael Morton Act wasn't around when I began prosecuting the Schaffer case, the one that was down in the 339th, my philosophy on that is that you don't worry about whether it's incriminating or exculpatory. You turn over everything.
Yeah.
And so in that case, we had a complete open file. I didn't have a work product file, as prosecutors will do. You know, when prosecutors here in Harris County, or most counties, are working on a case, they know that they'll make their file available to the defendant, but they always have a work product file. And it's sort of sealed, and we're told you never look in the work product file. To me, the title ought to be Brady material.
Right.
Because anything they don't want you to see is usually the very thing you need to see.
Exactly.
All right? But we can't violate that, or you lose your ability to look into an open file. But when we were prosecuting Mr. Schaffer, my co-counsel, and I, Nicole DeBoard, just decided, well, whatever we have, we just turn over to the defense. And so anytime we received something from our investigators, we would make a copy for the file and a copy for the defense. And I learned that not only because I'm a defense lawyer, and I think that's the way it ought to be, but I've tried cases in Los Angeles, and capital murder cases. And there, every time the police officer would go out into the field and interview somebody, he would fax not only a report, but a copy of his notes to me and the prosecutor at the same time he was putting them in the case file. And that's the way it's always been in California.
Yeah.
We're way behind the curve, as are a lot of states, and especially the federal government. But they've always had totally open discovery. And there's nothing in the prosecutor's file that you don't have in your file. So if you lose the case, it's because you were supposed to lose it, and not because somebody handicapped you for presenting a proper defense. So, you know, if we get to the point now where there is a case that is filed, I can assure you that we'll go well beyond whatever they teach us at prosecuting school as to what you turn over, and simply just turn over everything. I mean, nobody should be convicted or put on trial when there's evidence that would suggest that they didn't do what they're accused of doing.
Sure.
And Ken, what is the reason for appointing you as special prosecutor for this case?
Well, a few things. First off, the judge wanted to appoint somebody who was not from that community, because it's a relatively small community and there are a lot of connections and relations between the local bar and the Attorney General. You know, it's not like Houston or Dallas or San Antonio, where, you know, there could be a politician or a lawyer you've never heard of who's in your same town. This is a small place, so you wanted to get somebody that was from out of town.
So an outsider.
Right. And I had experience as a special prosecutor in a complex white-collar case. Probably, you know, well over half of my cases are white-collar, and so I understand how to, you know, investigate them, how to try them. So it's not like I have to get up to speed on how to handle a securities fraud case or a fraud case at all. And he wanted to get somebody that had prior experience. And both Brian Weiss and I had prior experience as a special prosecutor. And so that's why he contacted us to see if we'd be willing to do it.
So why did you get appointed as special prosecutor on the first case? For the same reason, the white-collar defense you've done?
Well, in the first case, it was interesting that the defendant in that case, Mr. Schaffer, when he was stealing all the money, what he started doing, you know, if you think about it, $9 million is a lot of money to get rid of.
Right.
And when it's not your money to begin with, you become very careless and reckless with it. So it was sort of interesting. He started buying comic books with it. And he got to the point where he had so much money, he started buying expensive comic books, like $800,000-$900,000 comic books at auctions. And, you know, maybe the comic book was worth $700,000, but he'd go in and bid $800,000 on it just to get it, to make sure he got it. So he sort of changed the marketplace for collectible comic books. Well, he had so many of them that they were, when the search warrant was run on his house by the district attorney's office, there were crates and crates of comic books all over his house. He hadn't even taken most of them out of the crates that they arrived in.
That's good.
Yeah, I mean, there was just too many. So they ran a search warrant, he became a fugitive, and they took all the comic books and hid them, they put them in a storage locker as evidence. Well, apparently a couple of the DA investigators who were charged with seizing and inventory in the comic books decided to walk off with a handful of them. And one of the investigators flew up to Chicago, sold them to a comic book dealer who soon realized that they were stolen and contacted the FBI. And so federal charges were filed on one of the DA investigators. As a result, the Harris County DA's office could not prosecute the case, so they recused themselves. And they came in and asked the judge to appoint the Montgomery County District Attorney's Office to take over the case. Meanwhile, the defense came in and they said, well, we have a guy we want you to appoint. So the judge felt it wasn't ethical for either side to suggest to her who should be prosecuting the case. I mean, you can't have the defense lawyer saying, well, I want Joe Smith to prosecute, and the DA's going, no, we want Tom White to prosecute.
Yeah, like a conflict.
Yeah, so she said, you know what, y'all go away and I'll come up with somebody on my own. So she started making inquiries about who does a lot of white-collar cases, because it was a pretty intricate fraud scheme. I mean, it was very well thought out. And she wanted to bring somebody in who, you know, did a lot of white-collar cases. Well, one of them was Mac Seacrest, but Mac was involved in another special prosecution. One was Jim Mount. He was involved in another one. And then my name got brought up, so she called and asked if I would do it. So Nicole DeBoard and I got in, and then we had two great investigators, one who was former IRS and one was a HPD detective for 41 years. And so we brought them in, and over about a year, they really unraveled the whole scheme and did an excellent job.
So in hindsight, having been a special prosecutor and, of course, a defense attorney, which one do you like better?
Oh, defense attorney by far.
Good. No regrets?
Oh, none at all. I you know, getting out of law school, I never prosecuted anybody, never wanted to. I worked for Racehorse Haynes for 6 years before I ever, you know, even went to law school. Right. So to me, it was just, that's all I ever thought of doing. I never wanted to be in a position of putting people in prison in order to make a living.
Yeah, I want to kind of transition into you working for Racehorse and everything. And I think we have a picture of your life before lawyering. If we can pull up the what we affectionately call the Jesus picture. I think she has that for us to pull up. Do we have it, Twee?
Oh, we don't have it.
We don't have it.
Oh, shucks.
Oh, man.
Oh, well.
I thought we had discussed prior to the show bringing up the Jesus picture for everybody to see, but...
It was before the Paxton special prosecution, and
that's
we don't want to taint that with the Jesus picture.
That is true, but...
Good going.
You mentioned you started out, I think, as I recall, and, you know, I've known you for a while. You went to UT, you were, for undergrad, you were a drama major there. And at some point, I guess you came into contact with Racehorse Haynes very early on in your college career and watched him try some cases.
I did. It was interesting. I was a drama major at UT. And one day I got a call from my brother Randy, who was a fairly young lawyer at the time. I think he'd been a lawyer for a year or two. And he was working for Racehorse. And he said, hey, we're in Austin trying a case. Come have lunch with us. So I got over to the courthouse about 2 hours early, an hour and a half early. And when I walked in the courtroom to wait for them to get through, Racehorse was getting ready to cross-examine a witness. And I listened to this witness testifying, and you know, I just found it, you know, kind of interesting. I thought, man, this guy's really guilty. I mean, this witness is just crucifying this defendant. And I'd never seen a trial, but I thought, well, this guy's obviously guilty. But then I watched Racehorse Haynes cross-examine this guy. He didn't have a note in his hand. Just sat right in front of him. Haynes was smoking his pipe, because back then you could smoke in court. And he's sitting there smoking his pipe and cross-examining the guy. And by the time we got to lunch, the guy was just a blithering idiot on the witness stand. I mean, Haynes just literally totally discredited this guy to the point where everything he had said, you just forgot about. And I realized that, you know, this is theatrical. This is real life, you know, drama going on in front of my eyes. And I was just mesmerized by Haynes.
Was that the moment that you think you probably wanted to become a lawyer?
No. There was the next day, though, probably, when Haynes and I went back every day because I wanted to see this trial. And we were talking at lunch. He's like, well, why do you want to be an actor? So I talked to him about it. And, you know, I'd acted since I was a little kid, and I was just always interested in it. And he said, you know, you'd probably be pretty good at it. He said, and then you'll hit about 40, 45 years old, and you'll be in New York, and I have no doubt in my mind you'll be the coolest waiter at the restaurant. And he said, you know, the world really doesn't need any more Jewish waiters in Lower Manhattan. He said, but, you know, you might think about going to law school. And so he said, why don't you come work for me this summer and see what you think?
And you started out as an investigator, right?
Yeah, so I showed up at his office early in, you know, like 1st of June, early in the morning, and he had an investigator back then. He said, work with him. And so I worked with this guy and spent the next 5, 6 years. I changed my major, decided to major in psychology, and started thinking about law school. But I would work for Haynes, and then I quit right after I graduated. Just decided to take time to work for him all through law school, and got to work on good cases. The Cullen Davis murder case I was on from, its inception until the end. And so I got to sit in trial with him. I got to spend a lot of time learning how to cross-examine witnesses, how to investigate. And so by the time I got out of law school, I'd already been through so many cases with Haynes and Mike Ramsey and Ray Bass and my brother that, I pretty much, well, actually when I was in law school, I tried my first case. And it was just all from watching these guys in action and learning how they do it.
And then you went on to become an associate with Haynes, and I guess it was Haynes and Fullenwider back then.
No, actually, after law school, I went in with my brother and a group of 4 or 5 other defense lawyers. And Haynes at that time, I think he was paying $12,000 a year. And
your brother was actually paying more than that?
Right.
No, I didn't get paid anything. I rented an office from them. They had an extra office, and I paid about $200 a month for it, and just started out on my own. But I was around really good lawyers, so I would get advice from them. I would get referrals from them from time to time, and so I just kind of taught myself as I went along.
Sure.
But taught myself after having a good foundation that I developed working at Haynes and Fullenwider.
So what was the practice like when you first started out?
A lot different than it is today. There was
no Michael Morton.
Well, there have been a lot of changes in the criminal justice system because of the philosophy of the community today versus what it was then. It was, I hate to sound old or something, but it was a nicer, kinder time back then. And I'll use the federal courts as an example. When I started practicing law, I remember, there was a philosophy in the federal courts that every sentence was presumptively probation. If a guy got convicted of committing a federal crime, then he started out looking at probation unless the probation officer or the government could come in and show some aggravating factors. Maybe he had been in trouble before. Maybe there was violence used. Maybe there was something in particular about his conduct or the offense itself that made probation inappropriate. But that was always the starting place. There was always a presumption you were entitled to bond. And so because after all, you're still innocent according to law. So why should you be held without bond? Over the years, though, that changed. And now there's a presumption that every sentence is incarceration, and heavy incarceration, unless you can show that the sentence ought to be reduced from whatever the presumptive guideline level is. There's there's a presumption in most federal criminal cases that you're not entitled to bail. So it's crazy. You can go over to any part of Houston right now and walk up to somebody and go, I don't like the color shirt you're wearing, and shoot them in the head, and you'll be out on a $30,000 or $40,000 bond. You get caught with a pocket full of crack or methamphetamine over in federal court, there's a presumption you don't get out on bond, and you'll spend the next year or two in jail while your case is awaiting trial. So it's just the world sort of turned upside down in terms of, crime and punishment and people's attitude. We have legislators, we have congressmen, we have state senators, and Ted Cruz, and these guys go into government and they talk about how we want smaller government, we want less government. In fact, that's the Republicans' whole mantra, is less government. And yet, every time they go into session or they go back into the well of Congress, first thing they do is try to pass more laws.
And more criminal laws at that. I mean, we end up with more crimes under the United States Code, it seems like, every year.
Exactly. Outside of the Michael Morton Act, I can't remember the last time a favorable defense bill was actually passed.
And certainly not at the federal level.
Yeah, it's always, how do we toughen the sentences? How do we make more things criminal? Things that weren't criminal 10, 20 years ago are criminal now. You see very few things repealed. You see very few laws that are passed to afford more rights to the defendant. But we see laws virtually every single session that will criminalize more conduct. Today there's 150 things you can't do. 2 years from now, when they're back in session, it'll be 175 things, because they have to go there and justify their existence. If they go off to the state legislature and they don't introduce a bill and they can't get a bill passed, why is anybody going to vote for them? When somebody runs against them, they go, well, that's an ineffective legislator. They couldn't get one bill passed. So what's an easy bill to pass? What's a bill that nobody's going to oppose? Something to outlaw something. You know, if you look at a child sideways, it's a third-degree felony, you know. If you do something against children, if you do something against women, if you do something against men, if you do something against anything, it's easy to criminalize that and get support for it from other legislators, because nobody wants to be perceived as weak. Toughen sentences. Let's do away with parole. That's easy, you know. It used to be every sentence was parolable. Now there's so many sentences you can't get parole for. You can't get probation. Well, you get parole, but you got to do at least half, which is sort of a signal to the parole board to make them do the whole sentence. There's so many cases now you can't get probation for, deferred adjudication for. So, and it just keeps getting worse and worse and worse.
And Ken, I want to ask you, how much of that do you think is reflective on the war on drugs that took place really in the ebbs and with Ronald Reagan and Nancy Reagan and all that stuff?
Well, I think the pendulum's swinging back a little bit on that. You know, back in the 80s when Reagan was in power and they came out with the war on drugs, you know, prior to that, when I started practicing law, in federal court, sentences were relatively low, and so there were lots and lots of trials. I mean, I had been a lawyer less than a year, and I was trying a 3-month-long federal conspiracy case. And I left that and tried a case that was a month long, you know, 2 weeks later. Almost every case went to trial, and if you lost, your client might get, you know, 3 years, 5 years, 8 years, and under the law at the time, they had to serve a third of the sentence before they were released.
Right.
No less than 1/3, no more than 2/3. So you could have a guy that got 6 years in prison, he's going to serve 2. Well, in '87, the guidelines came into effect, which was sort of a part of that war on drugs. If we're going to win the war on drugs, first thing we have to do is put all drug users in prison, all drug sellers in prison, anybody that profits off drugs in prison, anybody that dreams about drugs in prison. So they came up with all these very, very tough drug laws, and then had the guidelines to go along with it. So possession of any amount of drugs in federal court, and you're going to prison. There's no probation. There were firm mandatory guidelines in place and mandatory minimums, which we had never had before. So even a small amount of drugs could get you 5 to 40 with no parole. And you know, if your guidelines were 10 to 12 years, most of the judges were not going to go below the guidelines. They couldn't go below the guidelines, or the government would appeal. Now, though, we see that, you know, the Supreme Court said these guidelines are no longer mandatory, they're advisory. And we have prosecutors now that is weird, it's good, but, you know, that think, well, okay, 10 years is too harsh, you know, let's try to get it down from there. We see people that are thinking that the sentences that are being meted out to people are just too harsh.
Yeah.
And so the pendulum is coming back, you know, in our favor, and people are starting to realize you can't just lock everybody up. You can't. I mean, it's, you know, at a time when the federal government keeps shutting down, you know, every 6 months or so.
The reality is the budget's just not there.
Well, yeah, it's $20-something thousand a prisoner.
Yeah.
The only way you're going to reduce that is you got to figure out how do we let people out of prison that don't really need to be there? Why are we spending more money to keep people locked up than any other country in the world? Yeah. And we have more prisoners than any other country in the world. It can't be that all these guys are just so damn bad that we have to keep them locked up and use our tax money to lock them up. If you pay $50,000 a year in taxes, that $50,000 is earmarked solely to keeping 2 guys locked up. One of which probably doesn't really need to be there.
We've hit the 8:30 hour, so I want to kind of reset the show a little bit. We're talking with Kent Schaffer tonight, HCCLA past president, and we're going to open up our phone lines and take calls. We're also taking your questions on Twitter at HCCLA_TV. We've got the phone number at the bottom of the screen. We've got our first caller of the night, so I want to welcome in our first caller. Hello, welcome to HCCLA Reasonable Doubt.
Where's the caller?
Should come over the speaker.
Oh.
Hello?
Hello.
Hello.
Oh, hi, my name is Ms. Malvo.
Yes,
Can
hi.
you hear me?
Yes, we can hear you.
And I have a son that's been locked up 21 years on a 36-year sentence. And every time he goes to his parole hearing, they denied it. And that's like 4 or 5 times he went. For one parole officer, she falsified the documents saying that the inmates didn't want to come to the interview. And he said, well, Mom, that's not true. So I'm wondering, what could I do? First of all, when he went to court, he said, Mom, that's not even the gun I had.
Well, ma'am, I hate to stop you there, but we're actually not allowed to give legal advice on the show. The only thing I can tell you is I would contact a lawyer and run those facts by a lawyer and contact them on a private line, not on a television, and get some advice privately on that. But we can't do that. Our rules prohibit us from giving any legal advice on the show.
Are you still there?
Are you still there?
No.
Okay. Well,
Okay.
Bye.
Well, actually, and also we have a Twitter question coming up for you. All right, here we go.
I've never had a Twitter question.
You have
you
your
got
first,
your first one.
All right, it's Mr. Schaffer.
Is it a real person?
It's a
It
real
is a real
person.
person.
He is real, I believe.
All right.
Do you think that your experience as a defense attorney will make you a better and more objective in your prosecution or as a special prosecutor?
Absolutely, because I have no interest in charging or convicting somebody that has not been afforded all the rights that they're entitled to, and I will be extra sensitive to that. As a defense lawyer, people have said to me many times, how do you feel about representing somebody that's guilty and gets off? And I always think, that doesn't bother me in the least. What bothers me is if I represent somebody who's innocent that goes to prison.
Right.
That's the sort of thing that makes that it would be hard for me to live with. And thank God, after 34 years of doing this, I don't think that's ever happened. And so if I'm going to prosecute somebody, I'm not cutting corners. I have no political agenda. I'm not a Republican. I'm not a Democrat. So politically, I could care less if somebody's an office holder. And, the last thing in the world I would do is do anything to abridge somebody's rights, to deny them something they're entitled to, and to not give them every chance that they have to, defend themselves.
So you would give him a fair trial?
Absolutely, I would.
That's all we can ask for.
And I have no agenda in this deal. I'm not paid any more, any less if the case is indicted, not indicted. I just want to make sure that I live up to the responsibility I have to the court when I took an oath to make sure that justice is done. And however the outcome is, I'm fine with.
we have another question for you coming in on Twitter, and this is about your star-studded client list. And we all know that you've represented some pretty high-profile people in your time, and this person wants to know who is the coolest person you've ever represented?
The coolest?
It's pretty broad.
It's pretty broad. I mean, who's the coolest? Who makes you smile the most when you think about it?
Farrah Fawcett.
Well, that's a
Farrah Fawcett or James Prince, and there's night and day here.
right.
But both of them very affable, funny, smart, talented, interesting people. You know, and one of the things practicing law that we really enjoy is when we have interesting clients. They don't have to be celebrities. They don't have to be wealthy. They don't have to be anything other than interesting. And we all have characters that we've represented that you know, you go through your career and you remember them very well. Farrah was that kind of person to me. She was somebody that I represented her for many years, from not criminal stuff, but more business or entertainment-related work. Although some of her family was criminal.
Right.
But,
everybody has that uncle, right?
Exactly. An uncle, a kid, an ex-boyfriend. I mean, there's all sorts of problems. But just somebody that made me feel good about what I was doing. And James Prince is another. I've been working with Rap-A-Lot Records for 20-something years, and represent a lot of people that came through there, a lot of the local rappers in town, and some of the nicest people I've ever represented. You wouldn't think so, but they really are. And, you know, you start caring about them a lot, and you can't be any cooler than James Prince. You just can't.
Well, that's true.
He won't let you be cooler than him. I mean, it can't happen.
We're going to try the phone lines again. I think we have another caller. Hello, welcome to HCCLA Reasonable Doubt. Hello?
Hey, James, this is Rob Fickman.
Hey, Rob.
How are you?
I'm great. How are you?
good.
That was supposed to be anonymous.
Well, I don't give a damn. Kent, would you talk a little bit about how, with the advent of the guidelines and 5Ks during all the pre-Booker years, how it kind of turned us into snitch nation, and the race to the courthouse by the accused and some of their lawyers to flip and become snitches, and how it's the destructive element of the guidelines. Can you talk about that?
Sure, because I think that reflects poorly on our society as a whole.
I'm going to hang up and listen. Thank you.
Thanks, Rob.
Thanks, Rob.
What he's talking about is that, you know, there was a time prior to 1988 when I remember many of us, Dick DeGuerin, David Berg, Mike Ramsey, there were tons of us that would never represent an informant. If somebody came in and they said, look, you know, I'm guilty of what they said I did and I want to testify against my co-defendants, we just say, well, we're not going to represent you. There's thousands of other lawyers, go hire them. Because we just thought it was morally reprehensible to represent somebody who was trying to get out of trouble by laying it off on someone else. You know, and it's like, we can always find other clients, so go hire someone else. And people would go to trial if they believed that they were not guilty or if they believed that they could win the case. And they didn't want to be saddled with a felony or the threat of incarceration hanging over their head. Well, the guidelines came along, and all of a sudden you have mandatory minimums. And the only way you could get underneath the mandatory minimum or underneath the guideline, back at the time from the 80s, 90s, really up until about 5 years ago, the only way you could get out from under the guidelines and mandatory minimum sentences was to snitch on other people. So what started to happen is people who were probably not guilty or there was a marginal case on them, they had to either go to trial knowing that if they were convicted, they might get 15 or 20 years under the guidelines, no parole, or they had to tell on someone else. It was that easy. Well, what if there's nobody to tell on? If there's nobody to tell on, you create somebody to tell on. You know, maybe the three of us, you know, are good friends, and you and I go commit a crime, and we get caught, and we can't tell on each other. So what do? We tell on our buddy. Jimmy did it too. He knew we were doing it. Right. We saw so many cases where informants would come into town or come into court and just lie out of whole cloth on other people. Mr. Fickman, who called in, he and I've had a couple cases together back in the 90s and early 2000s where, you know, these informants would come in and you get through cross-examining and they would pretty much admit that they just made it up to get a sentence reduction. And sometimes they would say, and the agents told me to do it, or the prosecutors knew I was doing it, and the courts just sort of looked the other way. And the problem when you have harsh mandatory minimums is it puts people in a position where they're willing to lie to get out from under it. Now, the lawyers who refuse to represent snitches, there came a time where you just can't afford to do it because it's so common in federal court. You know, it just happens all the time.
Sure.
So if you want any kind of federal practice, you can't be so moralistic in your thinking that, you know, I'm not going to do something like that. Every now and then we get clients that refuse to become informants. Every now and then we get clients that want to go to trial, and sometimes they win and sometimes they lose. But they would rather go to prison than have to tell on other people and make things up or lay their problems off on somebody else. So, you know, I remember as a kid, I'd get in trouble. Other kids would get in trouble. They were friends of mine. And you'd start, you know, well, I did it, but so did he. And, you know, your parents would say, don't you snitch on your brother. Don't you snitch on your friend. And snitching was a bad thing. Nowadays, I mean, if you don't snitch, you're going to prison for a zillion years in some of these federal cases. Yeah. And so you have some defense lawyers who are, we call them throw-down snitch lawyers. They've never tried a case. They've never done anything except take people to the government and get them to snitch. I've got a case in San Antonio right now where these lawyers are doing backflips to make their client cooperate. I mean, they're thinking of every argument they can. The guy's going, I'm not going to cooperate because I don't want to lie. And if I tell the story you want me to tell, I've got to lie on other people, and I'm just not going to do it. So the client is, you know, sitting up straight, and the lawyers are just going crazy. Like, how do we turn this guy into a snitch?
So how do you fight against that when you do your defense? We have a caller, but
Yeah. Yeah, I want to get to another call. We got another call that's been holding on for a while now. Hello, welcome to HCCLA Reasonable Doubt. Hello?
Well, there goes that call.
the call's question was, how do you fight against snitching when you do that? When you're a defendant and everybody's snitching, what do you do as a defense attorney?
I don't tell people to snitch or not snitch. I tell them what their options are. And if somebody tells me I want to go to trial, I'm not going to talk them out of it. If they say I want to plead guilty, but I don't want to testify against other people, I don't try to talk them into it. And I've had several cases like that. I had one up in Massachusetts 2 years ago, and the judge said, look, I don't want to have to give you a 10-year mandatory minimum, and if you just snitch for the government and they'll file what's called a 5K1 motion for downward departure, I'll probably give you half or less than the 10 years. But without that, I can't do it. She goes, what I did was wrong. I sold cocaine. I can't blame somebody else for my problems. I'll go do my 10 years. And she did it. I'm not going to sit there and browbeat somebody into becoming a snitch. I mean, and part of the other deal, too, is even though snitching is more commonplace now, in some parts of town, in some communities, snitching is still dishonorable.
Yeah.
And people worry, especially a lot of these defendants from Mexico, they come up here and they start snitching on other people. Some of the cartels don't look too favorably on that. And they've still got family down in Mexico or Colombia or wherever they're from. They don't want to snitch for safety reasons.
Yeah.
All right.
I think we've got our phone line fixed now, so let's see if we can get the caller on the line. Hello, welcome to HCCLA Reasonable Doubt. Hello?
You're getting prank called.
Told me it was fixed.
Thick man, come on, stop calling in.
Yeah.
Hello?
Hey, can you hear me? Sorry, hello.
Yes.
Hello?
Hi.
Hello.
Okay, I've been keeping up with Kent Schaffer's career, and I think it's very impressive, and he's fabulous. My question to him is, when did you feel like, what made you, like we say in the mob, what made you, when did you become the main dude? What case?
When you started following my career?
Reagan administration.
I don't know any one case. I think probably early on in my career I tried 5 federal cases back to back, and I got good results in really all but one. But I think it was just a number of cases altogether. One of the first cases I tried, though, in state court was Eroy Brown. I was co-counsel with Craig Washington. Eroy Brown was a prisoner at the Ellis unit in Huntsville who was accused of killing the warden and the assistant warden. And, here's a black prisoner who'd been a prisoner several times who kills a white warden and a prison major. And so he lived and they died. So, back in the 80s, that was not a good environment. So they moved the case down to Galveston, and Eroy went through 3 trials. One was a mistrial, so he went through 3 trials altogether. He was ultimately acquitted of all of them. And when I first started, I was just out of law school, and I was investigating for Craig Washington, who was lead counsel. And halfway through, or right after the first trial, before the second trial, I got my law license. And so he said, well, come try it with us. And so I didn't have a speaking part in the second trial, but I did in the third trial. I got to question witnesses and do the final argument. And so we got an acquittal in that. So in my mind, that was what made my career, because probably my 3rd jury trial was a capital murder case that was a very high-profile case. I didn't really win the case. Craig Washington won the case, because Craig was one of the greatest lawyers who's ever been in Houston, Texas. And I was lucky enough that he kind of drugged me along with him. And, I got part of the credit for it. So I think in some ways that probably helped me to start my career on a high note. And then I started doing more and more federal work. And at that time, it was easier to win cases, and there was less risk,
Right.
You get convicted. I lost a 50,000-pound marijuana case in Galveston, Texas, and the judge says, I'm going to throw the book at your client. I've had enough of this marijuana smuggling, and he gave the guy 3 years in prison. And the guy served a year of it. So back then, people were willing to let lawyers take chances by going to trial instead of instinctively trying to work out a deal.
I was curious. from a personal standpoint. I mean, a lot of us in the legal community think one of your biggest strengths as a lawyer is your cross-examination skills. I mean, anybody who's ever watched you cross-examine a witness, particularly a snitch, knows that you're probably one of the best, not just in the city, but across the country in terms of cross-examination. But I want to know, what do you think is your biggest strength, and what do you think is your biggest weakness as a lawyer?
I think cross-examination. It's because I love it. I mean, to me, that's the most fun part of a trial. I've never been the type of lawyer who is happy or satisfied sitting at my desk reading slip opinions or law books all day and writing about what I read. I've been somebody who likes to be up on my feet. I like to ask questions. I like to hear a story and then unravel it. And, you know, most witnesses in a criminal trial have some motivation for testifying. Every now and then they just happen to witness something, but that's rare, especially in federal drug cases. And so they always say that cross-examination is the greatest truth-telling device that we have. It's where you break down a story to the most bare elements and the truth comes forward. And so to me, it's always been the most challenging part, but it's always been the most rewarding part, and I've always just loved it. You know, I have actually have fun preparing to cross-examine witnesses. And then the cross-examination, you know, there's that aha moment where,
Sure.
you know, a guy testifies on direct and he buries your client and everybody hates your client because this guy's such a good witness. And, you know, the judge's like, I've never heard a witness so good as this witness. And then you get up and you start cross-examining, and 2, 3, 4 hours into it, all of a sudden the guy says something that makes everybody turn around and look at him differently, like, wow, this guy's been lying the whole time. And when you have that moment, that's when you really, to me, feel like a lawyer. That's like, wow, I earned my money today, you know,
Yeah,
and
right.
you have a sense of satisfaction. Your client's happy, you know, you look at the jurors and they're nodding at you, and the judge treats the witness different. And it's sort of a magical moment in trial. It doesn't matter if you're getting paid $1,000 or $1 million to try the case. It's that intangible thing that
Kind of
gives
one of those
you
things you live for as a lawyer.
Yeah, exactly.
Yeah, you're blowing up the phone lines tonight. We got another call coming in, so let's appease the
3
audience.
people is blowing up the phone lines?
On this show, it
come
is,
on.
believe me.
Actually, this is the 4th one.
Yeah.
Yeah, 4, yeah, but one of them, the other one was Fickman.
Yeah, well, that's true. He does still count. Hello, welcome to HCCLA Reasonable Doubt. Thanks for calling.
I tuned in late. Have y'all commented on the Lisa Falkenberg Pulitzer-winning grand jury story? I'll hang up.
Thanks. No, we haven't gotten to that
What was
yet. He's
Lisa
asking about
Falkenberg.
Lisa Falkenberg and her Pulitzer Prize. I want to make this show about you, frankly, but she did.
Yeah, what does she have to do with it? No, but that's quite an honor.
It is quite
She
an
did
honor.
a great service by publishing that. You know, it's funny that the Chronicle, back in the 80s and 90s, they had all these investigative reporters like her that would do these exposés on the DEA, on the U.S. Attorney's Office, on Customs, on HPD. I mean, they called it muckraking, you know, where they would go out and really dig into things. That's what Lisa Falkenberg did. That's one of the first reporters I've seen do that in probably 10, 15 years here, because that just went against what the Houston Chronicle started doing meaningless stories about nothing. And so, you know, hats off to her. That was a great deal.
So we got a special viewer tonight, James, and he wants to know, how did you get involved in entertainment law?
Actually, through Farrah Fawcett. I was trying a murder case in Los Angeles, and Farrah had been assaulted by a boyfriend, but became her ex-boyfriend, and nobody would file charges. The police, you know, back at that time, it was domestic violence, and they figured, you know, so a man hits a woman, so what? Big deal. And nobody seemed to care about it, except for her. And she had a very close friend who she had gone to UT with that I knew. And he called me up, and he told me the story, and he said, do you know anybody in L.A. that can help her? And I said, well, you know, I don't know. I happen to be in L.A. Let me talk to this prosecutor I know. And I talked to this prosecutor in the L.A. District Attorney's Office. He met with Farrah. He filed charges. They prosecuted the boyfriend. And after that, she said, you know, I'm paying all these lawyers to do all these things for me, and nobody's doing anything I ask them to do. From now on, you're my lawyer. And for the next 12 years, every time there was any kind of legal problem, a contract, anything that came up, she would call me. I negotiated her reality show contract for her with the Bravo channel. It was back the first time Bravo did any original programming. And she said, you know, I'm not using these guys here. I need you to fly out here and negotiate a deal. And we did.
Oh.
Well, that explains Farrah Fawcett. How did you get with Rap-A-Lot? Because Farrah Fawcett and Rap-A-Lot aren't on the same plane.
No, but a lot of what I did for her involved entertainment-related work. And so, but my early experience with Rap-A-Lot was representing people in the community that were friends with James, or not, I won't say friends, that knew James Prince, that knew Scarface, that knew Pimp C, that knew Slim Thug, that knew all these guys. And back in the 80s, there was a group of guys who were tried. Johnny Binder was one, and Wayne Jefferson, and Bobby McAfee, and Martha Preston. They were considered the drug lords over Houston back in the 80s. Whether they were or not, you know, the government tried to paint them that way. There's another one, Johnny Hickman, and I tried many of those cases. I won a lot of them, and I lost some of them. But, you know, they all went to trial. We didn't plead. Nobody snitched. They were all hard-fought federal conspiracy cases. And so out of that, plus my background in entertainment law, I just started getting hired on all the cases.
That's good. And, do you think there was more honor in the way the practice was then versus now? More honor? Right.
I think there's more of a love for it. I hear lawyers all the time now that say they hate what they do. They don't enjoy it. It's, you know, they do it to make money. Back then, you saw guys that were, and girls that were really, you know, that just had a love for what they did. And because you got to try more stuff, especially in federal court. But, you know, now it's, especially in the feds, it's hard to get to trial on stuff. I mean, you can plead for 3 years or go to trial and get 30 years. You know, there's a big difference there. So you don't see as much. I think lawyers today are as good. You've got a lot of lawyers who are, you know, carve out a niche for what they do, and they're very good at it. It seems like there's a lot of acquittals in the cases that are being tried. And groups like Harris County Criminal Lawyers, you know, put together CLE programs, and they have social events to bring lawyers together to keep them interested and keep them pumped up to go in there and fight for their clients and do a great job.
We only got a few minutes left, and I think we're going to try and sneak in one more call if we can. So let's see if we can get them on the line. Welcome to HCCLA Reasonable Doubt. Thanks for calling.
How you doing?
Good. How are you?
Fine. The question I needed to ask, like the guidelines of today, does it reduce the person's sentence from the guidelines like back in 1994?
Yeah. So we only have a minute left. So let's try and be real quick.
What's the difference?
Well, I think, you know, they've just had the amendment to the guidelines, especially in the drug cases.
All right.
And so compared to the mid-'90s, I mean, now we've seen a 2-level reduction in the guidelines. So
yeah, there's two differences. In the drug guidelines, there is a two-level reduction from where they used to be. However, there's also the Booker case that came out, which says the guidelines are no longer mandatory. And so it used to be, before we had guidelines, the judge could give anywhere from 0 to whatever, but usually it's like in state court, you would negotiate the sentence. My guy will plead for 3, he won't plead for 5. Then the guidelines come in, they go, nope, the guidelines are 10 to 12 years or 12 to 15, and the judge had to follow them. Nowadays, the judge doesn't have to follow them. He just has to consult them, and he could say, well, I find the guidelines too high. Yeah. So now you have more judges willing to deviate downward from the guidelines. That's the difference.
We got to wrap up because we're out of time, but Kent, we appreciate you coming on the show.
My pleasure. Thank you for having me.
And I really hope that perhaps maybe after the Paxton case is over, we can get you and Brian Weiss back on and have a really rip-roaring good time with the two of y'all, because we had him on a couple weeks ago, and that was really good. So thanks for coming on, and we really enjoyed it.
Thank you for having me.
We appreciate everybody joining our show, and we hope you have a great night. And please like us on Facebook. You can get all the information on our upcoming shows. Follow us on Twitter. Send us your questions every week, and keep the calls coming in. Good night, everybody.